Good afternoon, Justice. Justice Henry Jean-Paul B. Inting, Justice Samuel H. Gerlan, Justice Josep Y. Lopez, and Justice Jose Maidas P. Marquez. The Philippine Judicial Academy Chancellor Rosemary D. Carandang, and Court Administrator Raul B. Villanueva. Joining us online are Justice Mario Victor F. Yonen, Justice Mario V. Lopez, the Deputy Court Administrators, Assistant Court Administrators, and Office of the Court Administrator officials, Executive Judges, and Presiding Judges of the First Level Courts. Judge Danilo S. Cruz, President of the Philippine Judges Association and its members. Judge Irineo M. Lustre, President of the Philippine Trial Judges League Incorporated and its members. Judge Ann Perpetual S. Rivera Sia, President of the Metropolitan and City Judges Association of the Philippines Incorporated, or METCIJAC, and its members. Integrated Bar of the Philippines IBP President Bert M. Escada and its members. Philippine Bar Association Incorporated President Rodel B. Volante and its members. Philippine Association of Law Schools President Hemi Lito L. Festin, Deans and Faculty members. Legal Education Board Chairperson Attorney Ana Marie Melanie B. Trinidad and its members. Philippine Association of Court Employees President Mr. Edmund De Having and its members. Also present physically and some joining us online are the distinguished members of the Committee on the Revision of the Rules on Summary Procedure and Small Claims Cases. Also physically present are the members of the media, with special mention to the Justice and Court Reporters Association, or JUCRA, and the Justice Reporters Organization, or JUROR. Virtually present are the Judicial and Bar Council, JBC, and Judicial Integrity Board, JIB members and lawyers. Mandatory Continuing Legal Education Office Governing Board members. Philippine Judicial Academy officials, Corps of Professors, and members of the Academic Council. Supreme Court officials and employees.
Bye. Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Mga kababayan, ang pambansang awit ng Pilipinas.
Alam ng puso, sa titik mo'y bumay, lupang binirang, tuyag ka ng magiting, sa mandulupin, di ka pagsisingil, sa nanalang tutok sa simulan, sa langit mo pagaw, ay hinatang tulang, awit sa paglayang minamahal, ang isang lang matawad mo'y tagumpay na nagtitigil, ang bituin at parang niya kailan ang may liwag-ibigin, lumalang araw ng buwan, bakit pagsinta, buhay langit sa piling mo. Ang higaya ng pagkay pag-aami, ang mamatay ng dahil sa'yo.
Ini pada lega eksaknya lah. Mestinya ini tu.
Please be seated. Good afternoon. Welcome to the media launch of the Rules on Expedited Procedures in the First Level Courts. I am Laura Cruz Herrera del Rosario, Deputy Clerk of Court and Judicial Reform Program Administrator from the Supreme Court Program Management Office. We're here today to present and share the rules on expedited procedures in the first level courts, which improves, recalibrates, reconciles, and harmonizes the 1991 revised rules on summary procedure and 2016 revised rules on small claims cases. Our distinguished speakers will discuss what exactly are the revisions to these rules. But before that, may we call on Court Administrator Raul D. Villanueva to deliver the welcome remarks.
I was told that we have a sanitation system which will allow the speakers to take off their masks. So with your permission, your honors, ladies and gentlemen, allow me to take off my mask as I deliver my welcome remarks. The Honorable Chief Justice Alexander Gasmundo and the Associate Justices of the Supreme Court, Senior Associate Justice Estela Perlas Bernabe, Justice Alfredo Benamin Kagiwa, Justice Henry John Paul Inting, Justice Samuel H. Garland, Justice Japar Limampao, the Chairperson, Vice Chairperson, and members of the Committee on the Revision of the Rule on Summary Procedure and Small Claims Cases, the Chairperson, Justice Maria Filomena Singh, and members of the Technical Working Group for the said committee, PILJA Chancellor, Justice Rosemary Carandang, colleagues and fellow workers in the judiciary, the executive judges and presiding judges of first level courts in attendance, whether in person or virtually, members of the media, guests, ladies and gentlemen. A pleasant and blessed Friday afternoon to everyone. I extend to you my warmest welcome to the media launch of the rules on expedited procedures in the first level courts, or if I may, the expedited procedures rules. Once again, the esteemed members of the Supreme Court and Banc have carried out with utmost distinction and precision their constitutionally mandated task to promulgate rules intended to accelerate and speed up the administration of justice, particularly for cases before the first level courts nationwide. The expedited procedures rules serve as a clear, unambiguous, and straightforward guide in handling cases covered by the rule on summary procedure involving both civil and criminal cases, and the rule on small claims pertaining mainly to civil cases. Thus, our first level court judges are now equipped with the most responsive procedural rules to aid them in the discharge of their increasing adjudicative work. Let me just update you that to help judges, especially those in the first level courts, to immediately be informed and familiarize themselves with the expedited procedures rules, the Office of the Court Administrator already issued OCA Circular Number 69-2022 dated March 25, 2022, furnishing all judges copies of the said rules. Likewise, per OCA Circular Number 79-2022 dated April 5, 2022, the pertinent provisions of Administrative Matter Number 08-8-07-SC pertaining to the collection of fees were revised to help the clerks of court compute the correct legal fees for small claims cases since the threshold amount was increased to 1 million. As the program for today's media launch includes a presentation of the expedited procedures rules by no less than Chief Justice Gasmundo himself, and a discussion of the salient features of the expedited rules, procedures rules, which will be done by eminent members of the committee and its technical working group, such as Supreme Court Associate Justices Garland and Midas Marquez, including Court of Appeals Justice Singh. Let me therefore conclude this welcome address by stressing that as I see it, Your Honors, and to everyone else, that at the preliminary stages of the proceedings, the present rules intend to strike a balance between saving time and costs on the part of the courts, but ensuring that the litigants are not denied their basic right to due process. Evidently, quality justice is not compromised despite the characteristic speed that the expedited procedures rules now offers. Given the importance of these rules, therefore, this media launch is a fitting event for the first level court judges and court users alike to be in step to maximizing the benefits that will be derived from these rules when these become effective by April 11, 2022. As we all envision a nation ruled by law and sustained by justice real time, let us welcome, therefore, this giant step in achieving that vision with joyful expectation that the rules and expedited procedures in the first level courts now richly provide and make available. Muli, malugod ko kayong inaanyayahan at binabati sa mapagpalang hapon na ito para nainilaan upang ipakilala at ipaalam ng lubusan ang rules on expedited procedures in the first level courts. Kaya mabuhay po tayong lahat, mabuhay po ang Korte Suprema at mabuhay po ang buong Judikatura. Maraming salamat po.
Maraming salamat, Court Administrator Raul Villanueva, for your very welcoming remarks. I need to extend time while we are sanitizing the microphone. But for everyone's information, the Court Administrator is also a member of the Drafting Committee, the so-called Committee on the Revision on the Rules on Summary Procedure and Small Claims Cases. I will talk to you more about the committee in a little while. But now, to present the rules on expedited procedures in the first level courts, it is an honor to introduce my boss, the Honorable Alexander G. Gasmundo, Chief Justice of the Philippines.
Please be seated. Since we are launching today the rules of expedited procedures, I will expedite my message. I will not give salutations. So good afternoon, everyone. The constitutional rights to the speedy resolution of cases and speedy trial guarantee that every litigant who seeks to enforce or defend their claims before the courts are not unduly burdened by the rigidities of legal proceedings. The Supreme Court is completely aware that the Filipino people place a high premium on timely adjudication of cases filed with the trial courts. The 1991 revised rules on summary procedure and the 2016 revised rules on small claims cases have been instrumental in providing the judicious resolution of civil and criminal cases through the simple and convenient modes of proceedings. These rules have assisted the litigants in adjudicating their legal disputes promptly and without needless delay. The enactment of Republic Act No. 11576 that expanded the jurisdictional amount cognizable by first-level courts in civil cases to 2 million pesos, among others, led the Supreme Court to revive and constitute the Committee on the Revisions of the Rules on Summary Procedure and Small Claims. The objective of the committee was not only to adjust the cases covered by these rules, but also to incorporate recent developments in procedural and substantive law and jurisprudence, the best practices of the trial court judges, as well as adopt technological advancement. Through the collective efforts of the committee, with Associate Justice Henry John Paul Bienting as committee chairperson, Associate Justice Samuel H. Garland as committee vice chairperson, and its team members and secretariat, the proposed rules were timely submitted to the Supreme Court and Banc. In turn, the members of the Supreme Court thoroughly deliberated the provisions to ensure that the essence of the speedy resolution of cases and speedy trial are intact and resolute. In record time, the Supreme Court and Banc approved on March 1, 2022, the rules on expedited procedures in first-level courts under AM number 08-8-7SC. The rule will prospectively apply and will take effect on April 11, 2022. To the members of the bench and the bar, to our friends from the media, to the various stakeholders, and to the general public, I am proud to present the rules on expedited procedures in the first level court. It is the fervent hope of the court that these rules shall be applied genuinely and meticulously, so that every civil and criminal case covered therein shall be resolved appropriately without unwarranted delay. Thank you very much and good afternoon to all.
Maraming salamat po, Chief Justice Gasmundo. We are indeed honored to be in the presence of a hardworking Chief Justice and very accommodating. For the information of the participants, the Chief Justice, together with Associate Justice Henry Jean Paul B. Inting, envisioned this formal media launch of the rules on expedited procedures in the first level courts in order to make it known to all stakeholders. We also wish to recognize and congratulate the members of the Committee on the Revision of the Rules on Summary Procedure and Small Claims Cases. Chairperson, Supreme Court Justice Henry Jean Paul B. Inting. Vice Chairperson, Supreme Court Justice Samuel H. Garland. Members, Supreme Court Justice Jose Maidas P. Marquez. Court of Appeals Justice Maria Filomena D. Singh. Court of Appeals Justice Eduardo B. Peralta, Jr. Court of Appeals Justice Hermano Francisco D. Legazpi. Sandigan Bayan Justice Maria Teresa Dolores C. Gomez Estuesta. Court Administrator Raul B. Villanueva. Judge Evangeline C. Cabochan Santos. Judge Jackie B. Crisologo Sagisag. Judge Carla A. Fontila Abugan. Judge Carlo D. Villarama. Attorney Marcelino Michael L. Atanante IV. And Attorney Antonio Cesar R. Manila. The hardworking Secretariat. Attorney Ryan De Leon Ferraren. Attorney Hannah Joy A. Villarta. Attorney Barbie K. Perez Lopez, Attorney Theodore Joseph M. Humamil, and Attorney Camille Sue May Elting. It is now time to hear the message from the Chairperson of the Committee on the Revision of the Rules on Summary Procedure and Small Claims Cases. Ladies and gentlemen, please welcome Justice Henry Jean Paul B. Inting.
Thank you, Attorney Rosario. Chief Justice Alexander D. Gasmundo, Senior Associate Justice Estela M. Perlas Bernabe, beloved colleagues in the Supreme Court, members of the Bar, and distinguished guests, a pleasant afternoon. I am honored to welcome all of you to the media launch of the Rules on Expedited Procedures in the First Level Courts, crafted by the Committee on the Revision of the Rules on Summary Procedure and Small Claims Cases. As the chairperson of the committee, I am proud of the rules on expedited procedures in the first level courts. Taking effect on 11 April 2022, the rules on expedited procedures reflects the court's continuing commitment to constantly develop and improve laws on procedure geared towards enhancing the efficiency of judicial administration and giving effective service to the public. Guided by this perennial objective, the committee did not merely confine the revisions of the 1991 revised rules on summary procedure and the 2016 revised rules on small claim cases to the jurisdictional amount adjustment mandated by Republic Act number 11576, which expanded the jurisdictional amount cognizable by the first level courts to 2 million for civil actions to monetary claims. I am honored to have worked on the rules with Associate Justice Samuel H. Garland, Vice Chairperson of the Committee, Associate Justice Jose Maidas P. Marquez, and Court of Appeals Associate Justice Maria Filomena D. Singh, Chairperson and Vice Chairperson of the Technical Working Group of the Committee, Sandigan Bayan Associate Justice Maria Teresa Dolores C. Gomez Estuesta, and the members of the committee. I highly commend the efforts of the Technical Working Group of the committee which deliberately and exhaustively took into consideration relevant recent jurisprudence and issuances of other relevant rules of procedure, and the on-the-ground experiences availing in the first and second level courts, as shared by the brilliant member judges, RTC presiding judges Evangeline C. Chan Santos and Carlo D. Villarama, METC presiding judges Yaki D. Crisologo Sagisad and Carla A. Puntila Abugan. Recalibrating, reconciling, and harmonizing the coverage of the revised rules on summary procedure and small claims, the rules now provide for a very efficient and expedited procedure covering both summary procedure and small claims cases. Particularly, there will be a more simplified, inexpensive, and speedier disposition of small claims cases as the rules on expedited procedures introduces technological innovations and best practices for the benefit of the underprivileged and the court users in general. I express my deepest gratitude to my esteemed colleagues in the Supreme Court who deliberated on the draft proposed by the committee, incorporating their invaluable and intelligent suggestions, revisions. I also acknowledge the equally dedicated hard work and contribution of the committee secretariat headed by Attorneys Ryan De Leon Ferraven and Camille Sumay L. Ting. A publication which will be facilitated by the Philippine Judicial Academy will incorporate the text of the rules, a comparative matrix of the old vis-a-vis the rules on expedited procedures for the guidance of judges, updated small claims forms with translations in Filipino and Visayan for ease of use, and flowcharts and timeline for summary procedure and small claims cases, underscoring how expedited and efficient the new procedures are. I am positive that this publication will help pave the way for achieving the court's objective of ensuring simplified, inexpensive, and speedier disposition of cases. Thank you for your attention.
Thank you very much, Justice Inting. To discuss the salient features of the rules, particularly now on the common provisions and the effectivity of the rules, we call on the Vice Chairperson of the Committee on the Rules on Summary Procedure and Small Claims Cases, the Honorable Justice Samuel H. Gerlan.
Thank you, Attorney Laura Del Rosario, the Honorable Chief Justice Alexia Gasmundo, my colleagues in the Supreme Court, my chairman in the my working chairman in the First Division, Justice Ben Kadiwa, my the other member of our division, Justice Japsa Dimampao, the Philippine Judicial Academy Chancellor, the Honorable Rosemary Crandang, Court Administrator Raul Villanueva, Deputy Court Administrators, Assistant Court Administrators, and OCA officials, executive judges and presiding judges of the first level courts, the presidents, chairpersons, and members of the various organizations and offices who are joining us today, members of the media, Supreme Court officials and employees, and of course, the members of the Committee on the Revision of the Rules and Summary Procedure and Small Claims Cases who were duly acknowledged and recognized a while ago. A pleasant afternoon to you all. A Chinese proverb states, "The wise adapt themselves to circumstances as water molds itself to the pitcher." As my esteemed colleague Justice Inting mentioned earlier, the enactment of Republic Act number 11576 and 10951 raised a need to revisit the 1991 revised rule on summary procedure and the 2016 revised rules on small claims cases to reconcile and harmonize their provisions with the said laws. However, in their wisdom, the revision committee decided to maximize this opportunity to review the rules on summary procedure and small claims cases in their entirety in order to adapt to technological advancement and remain responsive and relevant to the changing needs and circumstances of litigants. As you may have noticed, the rules on summary procedure and rules on small claims cases were merged into one set of rules entitled Rules on Expedited Procedures in the First Level Courts. The rules on expedited procedures are broken down as follows. Rule 1, Applicability. Rule 2, General Common Provisions. Rule 3, Summary Procedure. Rule 4, Small Claims. And Rule 5, Effectivity. For today, I was tasked to present the salient features of the rules on expedited procedure, particularly Rules 1, 2, and 5. I will no longer read aloud every provision since this will be flashed on screen anyway. Instead, I will focus my time on the changes made by the revision committee. And let's begin. As is apparent in its title, these rules shall be applied by the metropolitan trial courts, the municipal trial courts in cities, the municipal trial courts, and the municipal circuit trial courts to the cases enumerated in Rule 1, Section 1, falling within their jurisdiction. The following civil actions are considered as summary procedure cases. In item 1A, forcible entry and unlawful detainer cases remain covered by the rule on summary procedure. The only change made was on the attorney's fees that could be awarded, which was increased from 20,000 pesos to 100,000 pesos. In item 1B, we find one of, if not the most significant amendment to these rules. Here, we see that the threshold amount for all civil cases except probate proceedings, admiralty and maritime actions, and small claims cases was increased to 2 million pesos. Aside from that, admiralty and maritime actions were also added as exceptions to the coverage of the rule on summary procedure. Considering that admiralty and maritime actions may require a more thorough determination of the issues to a trial, the revision committee decided to exclude these cases from the coverage of summary procedure, and instead, they will be governed by the regular rules of procedure. Under item 1C, complaints for damages were specifically included to remove any doubt as to whether these cases will be covered by rule on summary procedure. Of course, it goes without saying that the claim should not exceed the new threshold amount of 2 million pesos. Because of the increase in the jurisdiction of the first level courts, item 1D on enforcement of barangay amicable settlements where the money claim exceeds 1 million pesos was added under summary procedure cases. Since the parties in these cases have already effectively come to a settlement, there is no need for another full-blown trial. Cases solely for revival of judgment under item 1E were also included as summary procedure cases, since this should be simple enough to not require a full-blown trial. And last, under this section is a civil aspect of a violation of Batas Pambansa Bilang 22 or the bouncing checks law if no criminal action has been instituted therefore. Although, as you will see later, the criminal action for a violation of BP 22 shall also be governed by the rule on summary procedure. Next, we have small claims cases. The most significant amendment here is the increased threshold amount of 1 million pesos, exclusive of interest and cost. The revision committee also included a definition of a small claim as an action that is purely civil in nature, wherein the relief sought is solely for the payment of a sum of money. This means that the moment that the complaint includes a prayer for relief, aside from payment of a sum of money, or when the action is coupled with provisional remedies, the case will not be governed by the rule on small claims, even if the amount claimed is less than 1 million pesos. A small claim may be for money owed under any of the following contracts listed under Rule 1, Section 2A. The enumeration here is essentially the same as in the 2016 revised rules on small claims cases, except for the deletion of contracts of mortgage. The revision committee found it unnecessary to specify it as a separate item, considering that contracts of mortgage are deemed covered under contracts of loan as mere accessory contracts thereto. As regards contracts of loan, the revision committee added the catch-all phrase, other credit accommodations, to clarify that the rule covers transactions that may not technically be considered as loans, but are nonetheless part of the banking business. An example of this is credit card debts. For contracts of sale, the revision committee limited the coverage of the rule on small claims to contracts of sale of personal property only. Contracts of sale of real property were deliberately excluded because of their complex nature. Aside from money claims, cases stemming from contracts of sale of real property usually involve other legal issues necessitating professional legal advice and trial for their resolution. In my experience as a lower court judge, these kinds of contracts involve the applicability of the Maceda law, issues on rescission or validity of the contracts, and others. Hence, contracts of sale of real property cannot be covered by the rule on small claims where the parties are prohibited from being represented or assisted by lawyers. The revision committee removed liquidated damages arising from contracts from the coverage of the rules on small claims, considering that liquidated damages usually involve other legal issues such as validity, breach, and enforceability of contracts. The parties should be assisted by counsel in tackling these matters, and instead, liquidated damages arising from contracts may be covered by the rule on summary procedure, provided that the claim falls within the threshold amount. Lastly, when the money claim arising from the enforcement of a barangay amicable settlement does not exceed 1 million pesos, it will be considered as a small claim. As for criminal cases, the revision committee basically reproduced enumeration in the 1991 revised rule on summary procedure, save for a few changes. First is the addition of violation of BB 22 or the bouncing checks law. Second, the length of imprisonment and amount of imposable fines were adjusted following Republic Act number 10951 as follows. The length of imprisonment was increased from 6 months to 1 year. The imposable fine was increased from 100,000 pesos to 50,000 pesos. The imposable fine for reckless imprudence resulting in damage to property was increased from 10,000 pesos to 150,000 pesos. If the prescribed penalty consists of imprisonment or a fine, then we will refer to the length of imprisonment to determine whether the rule on summary procedure will apply. Having said all that, I want to emphasize that all other cases not included in the enumeration under Rule 1, Section 1, shall be governed by the regular rules of procedure. Similarly, when the plaintiff's cause of action is pleaded in the same complaint with another cause of action subject to the regular procedure, the case will not be covered by the rule on expedited procedures. You will notice that the revision committee opted to use the term regular rules of procedure instead of referring specifically to the 1997 Rules of Civil Procedure or the 2019 amendments thereto to allow for flexibility for future amendments to the Rules of Civil Procedure. We now move on to Rule 2 and General Common Provisions. Section 1 clarifies that the regular procedure shall apply even in cases covered by the rule on expedited procedures where there is no specific provision found in said rules. The regular rules shall also apply in supplementary capacity, but only insofar as not inconsistent with the rules on expedited procedures. In case of inconsistency, the rules on expedited procedures shall always prevail. Under Section 2, the Revision Committee merged all the prohibited pleadings and motions in both the 1991 revised rule on summary procedure and 2016 revised rules and small claims cases. The following additional items were also incorporated. Item B, motion to hear and or resolve affirmative defenses was added to mirror the tenor of the 2019 amendments to the Rule of Civil Procedure, which is to ensure that when a case is filed, all arguments should be contained in the complaint and in the answer. Item J, the second sentence was added, providing the presumption that any motion for postponement is dilatory except for the grounds stated therein. Item K, rejoinder. Item M, motion for or complaint in intervention. Item N, motion to admit late judicial affidavits was added because the intention is that all the affidavits of witnesses should already be included in the initiatory pleadings. And finally, item O, motion for judicial declaration of probable cause is an addition to the rules on expedited procedures, although it is already considered a prohibited pleading by the lower courts. Section 3 on video conferencing is a new section without any counterpart provision in the existing rules on summary procedure and small claims cases. This is one of the updates made on the rules in order to adapt to the current technological milieu. This provision aims to make the rules compliant or consistent with the current rules and video conferencing. The revision committee deliberately avoided referring to a specific administrative order so that the rules on expedited procedures will not be in conflict with any new administrative guidelines and video conferencing which the Supreme Court may issue. What we need to remember from this provision on video conferencing is that the courts are given discretion to determine whether the conduct of a video conference is proper under the circumstances. Section 4 on service pursuant to international convention was added to clarify that service of pleadings pursuant to the Hague Convention is valid. And finally, Rule 5 on effectivity. This is an essential point that I cannot overemphasize. The rules on expedited procedures will take effect on April 11, 2022 and shall have a strictly prospective application. This means that all pending cases covered by these rules, which are currently before the second and first level courts, shall remain with and be decided by the same courts based on the rules applicable to the time these cases were filed. Meaning, the courts must continue to apply the existing rule on summary procedure and rules and small claims cases for all pending cases prior to the effectivity of these rules. For example, if a complaint for unlawful detainer was filed today, April 8, 2022, it will still be covered by the 1991 revised rule on summary procedure. Again, the rules on expedited procedures shall have a strictly prospective application. And with that, I pass on the mic to my esteemed colleague, Justice Marquez and Justice Singh, to discuss in detail the rules on summary procedure and small claims cases. Thank you.
Thank you so much, Justice Garland, for discussing the salient features of the rules, particularly on the common provisions and the effectivity of the rules. To provide further discussion on these rules, particularly on the rule on small claims, we are fortunate to have with us today Justice Jose Maidas P. Marquez, also a member of the Committee on the Rules on Summary Procedure and Small Claims Cases.
Thank you, Attorney Elia. Good afternoon, everyone. My fellow members of the court, fellow members of the committee, fellow workers in government, our friends from media. Magandang hapon po sa inyong lahat. My assignment this afternoon is to give the salient features of the new or revised rules on small claims cases. As we all know, there's a rule on expedited procedures in the first level courts, mainly comprises rules on small claims and summary procedure. No? So for my assignment, I am tasked to give the salient features on small claims cases. No? So, of course, the most distinct feature is that the court has increased the value of the claim to 1 million. This is in Section 1 of Rule 4, considering that RA 11576 has expanded the jurisdictional amount of first-level courts in civil cases to 2 million. So for small claims, the maximum amount that you can file is 1 million. It used to be 400,000 under the old rules. No? That is actually the for me, no, the most distinct feature of the small claims procedure. And then we have we have additional definitions, no, that is in section 3, business of lending and business of banking. No? So business of lending refers to any lending activity pursued with regularity, while business of banking refers to the business of lending funds obtained in the form of deposits. No? And then the third feature, salient feature, is in section 5, where we provided venue provisions for 2 or more defendants. No? So if there are 2 or more defendants, the court of the city or municipality where any of them reside or is holding business can be the venue if the plaintiff is engaged in the business of lending or banking and has a branch in that jurisdiction. And then we have also reduced the filing fee. This is in section 8 for cases dismissed without prejudice for failure to serve summons. No? So if a case is filed and then this case is dismissed because there is failure to serve summons, then if it is refiled within 1 year from notice of dismissal, the filing fee, no, is a fixed amount of 2,000 pesos only, inclusive of fee for service of summons and processes. No? Because it used to be that when a case is dismissed and when you have to refile it, you have to pay the full filing fee. No? So in these cases, when the case is dismissed without prejudice for failure to file to serve summons, then if it is refiled within 1 year, there's a reduced filing fee of 2,000 pesos. And then in section 9, we have enumerated the grounds for dismissal, where the judge can dismiss outright, no, upon the termination of the following. Just from a review, no, of the documents filed. No? So if there's no jurisdiction over the subject matter of the defendant or the defendant, another action is pending, the action has been barred by prior judgment, there is improper venue, no legal capacity to sue, no cause of action, non-compliance with preconditions, and failure to submit affidavits. No? So for these reasons, the claim can be outrightly dismissed by the court. And then in section 11, we have electronic filing and service. No? So we can now use email, facsimile, and other electronic means. No? Notices may be served also through mobile phone calls, SMS, or instant messaging, no? To make our procedure easier and faster. And then for service of summons, that's section 12, no? We have also laid down the timelines. No? So the summons should be issued by the court within 24 hours from filing of the claim, and then it should be served within 10 days, no, from the issuance by the sheriff. No? Then the plaintiff can also serve the summons within 30 days if returned by the sheriff without being served, or if it is to be served outside the court's judicial region. And then for hearing days, okay, the case will have to be heard within 30 days from filing of claim, or within 60 days if one of the defendants is from outside the judicial region. And then, of course, this is a feature also from the old rules. The judgment will have to be issued within 24 hours from the termination of the hearing. What happens? What happens if defendant does not file a response? This is section 14. If he appears during the hearing, then he can offer defense during hearing and given 3 days to submit documentary evidence. However, if the defendant does not appear during the hearing, then the court can render judgment within 24 hours from the termination of the hearing. And then the appearances, parties can appear at the hearing either personally or through a representative, provided that there is just cause, that a representative is appearing for the party, and that representative cannot be a lawyer. The representative also need not be a relative. Again, under the old rules, which has been retained in these new rules, lawyers are not allowed to appear in small claims proceedings unless the lawyer himself or herself is a party. Okay. And then it was mentioned earlier that small claims cases or hearings can also be done via video conferencing hearings. The court has been provided with an official platform to conduct video conferencing hearings. And this is with the use of our Philippine Judiciary 365 platforms. However, if a party cannot appear through our Philippine Judiciary 365 platform because for one reason or another, maybe he or she is not does not know how to navigate through our Philippine Judiciary 365 platforms, the court can allow the use of an alternative platform or instant messaging applications with video call features. So the court can use Viber, Facebook Messenger, and other platforms. And then we have also, finally, we have also improved our forms. Because when you file a small claims case, you have to go to court and then you have to fill up the forms. You can be assisted by our clerk of court. For now, with these new rules, we have come out with reformatted and updated, easy-to-use platforms with a checklist. And then it also contains guidelines for small claims procedure, and then the rights and options of the parties. And these forms are available in Filipino and other local dialects. Okay, so I hope those salient features will make it really much easier for our claimants to file these types of cases. That will be all for the small claims procedure. Maraming salamat po.
Thank you very much, Justice Marquez, for giving a presentation on your assignment, the rule on small claims. To also discuss the other salient features of the rules, particularly the rule on summary procedure, may I introduce Justice Maria Filomena D. Singh of the Court of Appeals, member of the Committee on the Rules on Summary Procedure and Small Claims Cases.
Good afternoon, everyone, especially to the chairperson of our committee, Justice Henry John Paul Inting, to our esteemed vice chairperson, Justice Samuel Garland, to the chairperson of our TWG, Justice Midas Marquez, to our very, very responsible and hardworking members of our TWG and our secretariat, to the Chancellor of the Philippine Judicial Academy, Retired Associate Justice Rosemary Carandang, and of course to our Court Administrator Raul Villanueva. Sa inyo pong lahat, mga kasama kong mga judges at sa mga members po ng Philippine Bar, and to the members of the media. So I'm supposed to discuss the rules on expedited procedures, the salient features in summary procedure. So let's proceed directly with the presentation. Some of these have been mentioned by Justice Garland already. Can we go to our first slide, please? So of course, as mentioned by every speaker who has stood before you today, this the major change really is brought about by the passage of RA 11576, the change in the jurisdiction of our first level courts. Although the revision of the rule on summary procedure has been long overdue. It was revised back in 1991. I was still in law school as with Justice Marquez. No, so let's go to the next slide, please. As explained by Justice Garland, now, because of the changes in the jurisdictional amounts, all civil actions except probate proceedings, admiralty and maritime actions and small claims will be covered if they do not exceed the amount of 2 million pesos. So the threshold amount is 2 million pesos. It's not very hard to remember. It's uniform, no, for all the types of cases except yung sa assessed value. Pagdating sa assessed value, sa 400,000 tayo. So we only need to remember two amounts, okay? And then compensation for damages, as I mentioned, 2 million, no? Ito lang po yung naiba. Yung cases for enforcement of barangay amicable settlement agreements, you may have heard from Justice Garland already. Those which do not exceed 1 million, no, may fall under small claims. But everything that exceeds 1 million will fall under summary procedure. So you may ask immediately, what about if it exceeds the jurisdictional level of 2 million for the MPCs or our first level courts? If it's enforcement of barangay agreement, does that mean that goes to RTC already? For that, you refer to the local government code, no, which expressly vested jurisdiction in first level courts for the enforcement of barangay agreement. So regardless of the amount, it will go to the first level courts, basta enforcement of barangay agreements. But the thing to remember is that now we have a distinction. Is it enforcement, which does not exceed 1 million, in which case it may be a small claim if it involves just payment or reimbursement of a sum of money. But if it exceeds 1 million, no, and it can be a summary procedure case depending on the nature, right? So let's go to the next slide. The other highlights would be the adoption of the rules under the 2019, revision of the rules on civil procedure. And what would be these amendments? Well, principally, what the contents of the complaint should be, no? So we have now adopted the provision which requires not only the names of the affiants of those potential witnesses, but likewise the summary of their statements in their affidavits, as well as other documentary and object evidence. And then on the next slide, we will see the other highlights, adopting provisions of the 2019 amendments, including the rules on filing and service, no, which are found in rules 13 and 14 of the 2019 amendment. So we file pleadings, we serve pleadings, no? And not only pleadings, but also motions and other court submissions. And at the same time, we allow service as well of these papers, court-bound and court-issued, using electronic means, no? And when we speak of electronic means, we are talking about not only email or facsimile, but other electronic means which may be authorized by the court later on. Please excuse me. I am negative. It's just that my throat is dry. Okay, so now we are allowing it, but consistent with the provisions in the 2019 amendments to the rules, the consent of the parties will be secured first. So at least that is carried over here in the expedited rules. The other thing is the service of summons is now also allowed to be done in a substituted manner through electronic means, no? So again, another adoption from the 2019 amendments. And then another important provision which we adopted from the 2019 amendments, which the judges will really welcome, is the service upon foreign private juridical entities which are not registered in the Philippines. Alam natin, marami tayong na delay, no, na cases pagka ganun ang defendant natin because we don't know how to serve them. So now it's not going to be a problem anymore. And then on the next slide, we have the increase in the coverage of criminal cases governed by the rule on summary procedure. And as mentioned by Justice Garland, we have increased this, no, to imprisonment not exceeding 1 year, no, from 6 months. Why was the increase proposed and approved by the court and bank? Because we wanted it to be in harmony with the provisions again of the local government code on the Katarungan Pambarangay law. Because under that law, no, it is up to 1 year imprisonment. So we didn't want any more distinctions kasi it confuses our judges also and also our litigants. So ngayon consistent na po sila. And then on the last slide, you will see the remedy. This really, for us, no, aside from the changes in the amounts, is the revolutionary amendment that has been introduced and adopted, that the judgment of the RTC in an appeal, no, from a judgment in summary procedure is now going to be final, executory, and unappealable. If you will remember, this was the revolutionary provision in the original rule on small claims back in 2008, no? And at the start, maraming po tayong narinig na objections dyan, but where are we now? No, the rule on small claims has been around for more than 15 years. It has been amended at least 3 times, no? But it has been the most singular, no, docket reducing program of the Supreme Court in terms of first level court docket. So ito po, hopefully, with the rule on summary procedure adoption of the final executory and unappealable decisions on review by the RTC, we will also see a similar trend, no, downtrend in the case dockets of our first level courts. Now, just to walk you through, because we want to emphasize to you how quick, no, we project the cases will be finished, no, under our expedited rules, I will walk you through this, no. So first, you start with a complaint in a summary civil case, no. There's an important difference between a summary procedure civil case and a summary procedure criminal case. Because in a criminal case, we actually have trial. But in a summary civil case, wala pong trial yan. Kaya talagang pwede nating pabilisin, no? So we start day 1 with the complaint, and you just do a compliance check for our judges who are with us today. And what is that? You check on the rule on verification, on the rule on certification against forum shopping. You check on compliance with the barangay conciliation requirement. Dati po, medyo ambiguous yung ating provisions in the 1991 rules. Hindi natin malaman kasi meron ding jurisprudence na hindi tayo pwedeng mag-dismiss kung hindi siya i-raise as an affirmative defense, di ba? So ngayon, hindi na, maliwanag na. Judges can do this motu proprio. You can dismiss if there is no attached certificate of conciliation before the barangay, no? So, and then you also check for the grounds for outright dismissal, which are enumerated in our new rules. And then let's go to the next, which is the summons. Now you are on day 5. Kasi summons is supposed to be issued within 5 days from the filing of a new complaint. So day 5 na po tayo. If the case is not dismissible for any of the grounds we mentioned, then the court must issue the summons, okay? Then let's go to the next one, which is the answer. Pag nag-issue kasi tayo ng summons, we are directing the defendant to file an answer already. And dito, kasi we gave the defendant a chance of having 30 days to file an answer because now we are requiring the affidavits to be attached. We are requiring all the evidence to be submitted. So we thought we should give them a longer period of time. So now we're on day 35, okay? So of course, dyan nalalabas yung affirmative defenses, and under our 2019 amendments to the rules on civil procedure, our judges have to resolve these affirmative defenses. Hindi na kailangan maghintay na maghi-hearing because they're not supposed to be heard unless the discretionary clarificatory hearing is called for. Okay, and then if no answer is filed, we know that we can render judgment based on the complaint already. So as early as day 35, okay? So 5 days for the issuance of summons, and then the 30 days if we have to wait, diba, kung magpa-file siya. As early as day 35 or 36, you can already render judgment based on the complaint if no answer is filed, no? Then, of course, we have the provision on reply, which we also adopted from the 2019 amendments. We are giving 10 days to file a reply. That's why you see on the screen, it's day 35 or 45 if a reply is filed. And of course, I hope that we are all aware already of the rule on reply. It's now only allowed, no, both in regular procedure and summary procedure if an actionable document is pleaded in the answer. And then we go to the next slide, which is the preliminary conference. Now we are on day 65 and 75 kasi we issued the notice of preliminary conference within 5 days after issues are joined, meaning after receipt of the answer or a reply, if there is a reply. But when do we actually hold the preliminary conference? We hold it within the 30 days from receipt of the answer or the reply. So kaya day 65 na tayo kasi kanina day 35. So that's day 65 If there is a reply, then that's day 75 already. So in the preliminary conference, although there will be no trial, so hindi siya technically pre-trial. So judges, no? So please let's remember this. We don't have a pre-trial in summary civil procedure because we are not going to have a trial. So let's properly call it preliminary conference, okay? So during the preliminary conference, however, you will do the same things you do in a regular pre-trial, like identification of issues and then stipulations and then adoption of certain documents which are admitted. So here, what is pertinent also is the preliminary conference brief. Dati in the 1991 rule on summary procedure, there is no provision for the submission of a brief, no? Kaya yan, laging issue yan dati. So now we made it clear already, we are requiring a preliminary conference brief because we know this will be a helpful guide to our judges. And the preliminary conference brief is supposed to be submitted to the court, no? At least 3 days before the actual preliminary conference. And then preliminary conference order, you are supposed to issue the preliminary conference order according to the new rules immediately after the preliminary conference. So medyo problema yun sa judges, no? Kasi baka sabi nila hindi pa ako ready kung ngayon lang, no? I have to type it, I have to list down all the evidence, etc., etc. So this is where our creativity comes in, no? We can actually already input all these things in our computers so that when we're holding the preliminary conference, ine-edit na lang po natin yan real time para by the time you bang your gavel and end the preliminary conference, you're just printing your preliminary conference order. I think you're familiar with this. We call this the automated hearing process. And I hope that you can apply this here para wala tayong delay, okay? And then of course, because this is preliminary conference, we have our CAM and we have our discretionary JDR, which we will show on the next slide. Now, the CAM is reduced to 30 days, no? Period which cannot be extended anymore from the referral after preliminary conference proper. And then JDR is reduced to 15 days. But JDR is in parentheses because we have made JDR discretionary on the judge. So if the judge feels that there is still a possibility of settlement, the judge can still refer it to JDR. Okay, but if the judge feels na wala na exhaust na talaga income, and even during the preliminary conference proper, hindi talaga mag-aayos, then let's not refer it to JDR anymore because that's just a useless waste of time. Plus, the other important thing to remember here is that now we're reversing the original practice. The original practice is that if there is JDR, the court to whom the case is originally assigned unloads it, diba? And then it will be raffled if the JDR is not successful. But this time around hindi, no? So the court kasi nag-aral na siya, nabasa na niya lahat ng mga affidavits, nakita na niya lahat ng ebidensya. So hindi na natin siya papa-inhibit, no? So what we will do instead is raffle it to a JDR judge, no? So who will have fresh eyes in trying to settle the parties. Pag nag-fail, balik siya dun sa original judge na naaral na niya lahat ng mga sinubmit ng parties. Okay, so that really saves time for all of us. And then this is day 66 to 95 already, depending on whether there will be JDR and also depending on whether on the second day after referral to come, for example, sinabi na ng parties hindi magse-settle. So wala na, we won't use up the 30 days actually. So that's going to be shorter. Kaya nilalagyan ko po ng allowance para you can see we have the minimum and the maximum days. And then, of course, if there is a successful JDR or CAM, that will come out as a judgment based on settlement, whether CAM or JDR, that will be credited to the original judge. No, I'm sorry sa JDR judge na magaling na nasettle niya, pero it will be credited to the original judge. Kasi ayaw na po namin kayong mahirapan unloading your case, di ba? To go to the JDR judge. Entry na naman po yan sa mga monthly report natin, no? So maraming datos na naman na magkakaliko-liko. Kaya hindi na po natin gagawin yon. It will remain with the original judge. If there's a settlement, it will be credited to the original judge. So wala na rin pong iraraffle na bago sa inyo, nakapalit, okay? And then let's go to the next one, which is the clarificatory affidavits and evidence, no? Some call this clarificatory hearing, but there's really no hearing that's going to happen. All that we will do is that if the judge is still in doubt about a certain factual issue, pwede pa rin magsabi si judge na submit additional clarificatory affidavits on any factual issue. Pag ganyan po, we give an additional 10 calendar days. So kaya hindi po ma-extend ang inyong period to decide, okay? Kasi yung ating clarificatory affidavits and evidence is supposed to be done within the 30-day period that you're supposed to decide the case. So hindi rin makakadagdag yan sa inyo. Kaya if we're thinking that it may afford us an extension of the 30-day short period to decide the case, hindi po, no? So do not do it anymore if it's not really necessary. So there, you will see that now we are on day 66 to 95 with an additional plus 10 if you are going to require clarificatory affidavits. But if we had JDR, it will be day 96 to 110 already. And then on the last slide, we show judgment already, no? And judgment is within 30 calendar days, as we know, from the issuance of the preliminary conference order if position papers are not needed. No, we are now giving the judges the discretion to require or not to require position papers. Kasi maganda ngayon, nasa inyo na lahat ng ebidensya from the very start. So you may no longer need position papers. So you can dispense with that and immediately decide the case after you issue your preliminary conference order. But if there are still issues in your mind, you can still require position papers. And the submission is the same. It's 10 days. And your 30 days will run from the expiration of that 10-day period. Now, if you decide to have clarificatory affidavits, no, you have to decide within 15 days from the receipt of the clarificatory affidavit. So mas maikli pa yon, no, if you do that. And then, of course, within 30 calendar days from receipt of the mediator's report or the JDR report. And then if the court, we mentioned this already. So please pay attention to our days. Now we're on day 105 to 135 if this is with CAM. And day 120 to 150 if with JDR, no? So, and that translates, please divide it by 30. Kasi hindi po ako magaling sa math. Pero I think 150 divided by 30 is 5 months. So isn't that going to be really fast, no? So talagang nakakatuwa po kung magagawa po talaga natin doon. And there's no reason naman that we are not able to do this because there's no trial in summary civil. Okay, and then we go to appeal, which is the proper mode of appeal, of course, is ordinary appeal under Rule 40. We file the notice of appeal and we pay the filing fees with the court, which render the judgment, the final order or resolution that is subject of the appeal, no? And then the period remains the same. It's still 15 calendar days. But the important thing, as we mentioned already, is that the judgment of the RTC will be final and unappealable. Now let's go to a walkthrough of the criminal cases in summary procedure. Let's start with day 1. Upon receipt of a complaint or information, the filing of the criminal case may either be through complaint or information in accordance with the rules and criminal procedure. And so in the determination of probable cause, let's go to the next slide. This is already day 1 to 10. We know that under Rule 112, no, the court is supposed to determine probable cause within 10 days from receipt of every new criminal case. Now, if it's commenced by complaint under summary rule, you dismiss it outright if there is no probable cause, and then you order the release of the accused if the accused is in custody. Now, if it's commenced by information, the court will determine the probable cause on the basis not only of the affidavits, no, and supporting documents of the complainant, no, as attached to the information, but we also give the accused a chance to submit counter affidavits, okay? And that usually coincides, no, the 10-day period that we give to the accused to submit counter affidavits in summary criminal usually coincides with the period within which we have to arraign a detained accused in summary criminal. So yun yung nagiging problema na usually ng first level courts because wala pa yung counter affidavits ng accused, hindi pa nakaka-determine ng probable cause because we gave him a 10-day period, no? Pero we have to arraign within 10 days because the accused is detained. So there's a seeming disconnect between those two periods. But we have tried to reconcile that. And the provision now, the rules now provide that when that happens to you, okay, so you gave the accused 10 days to file counter affidavits before you determine probable cause, But because the accused is detained, you have to arraign also within that 10-day period. If the period to arraign comes, like the notice of arraignment, you set the arraignment. If the arraignment date comes, but the period to file counter affidavit has not yet expired, you can give the accused the option, no? You ask the accused, do you want to still file your counter affidavit for purposes of determining probable cause? If the accused says, yes, I want to avail of that, then you have no choice but to reset the arraignment. Okay, but if the accused says, I'm waiving that, okay, that is waived only for the determination of probable cause. You are not waiving that for trial. You can still file your counter affidavits for purposes of trial, and you give the accused another period of 10 days, no? So na-extend pa yung period niya. So please remember that, ha? Kasi that has always been an issue with first level court judges in reference to detained accused. So we go to the arraignment and pre-trial. We are now on day 1 to 10 for our detained accused because we're supposed to arraign them within 10 days. And days 1 to 30, no, for the non-detained or the accused or at large, because we are given 30 days to arraign them. But of course, as you know from our continuous trial guidelines, arraignment and pre-trial are supposed to be conducted already on the same day. So we have adopted that in our expedited rules, no, in summary procedure criminal. And then we go to the next slide, which is CAM and JDR. And we have here the same rules in civil, no, same periods, 30 for CAM, 15 days for JDR, same rule, no, regarding the judgment based on compromise and to which court it will be credited. But the more important thing to remember here, and we have to remind you, is that the CAM and JDR only cover the civil aspect. Okay, so the criminal aspect, definitely, we cannot make that subject of a compromise because that will be against public policy. Okay, so you see the dates there or the days. So now we're on day 11 to 40 if there is CAM, if detained, no? And if detained with JDR, the maximum will be 55 days. And then for those non-detained, day 31 to 60 if with CAM, and for those who are at large, if there is JDR, an additional 15 days or day 75. And then we go to the next slide, which is the trial and the offer. Okay, so here you have 60 calendar days, no, for the prosecution. Lahat na po yun, lahat na ng witnesses ng prosecution, 60 calendar days. And then the defense will also have 60 calendar days also. Of course, hindi mandatory gamitin lahat, no? Hindi kailangan gamitin lahat kung isa lang ang witness. And then if the prosecution feels that rebuttal evidence is necessary, we give the prosecution 15 days. So you will see on the chart, no, kung ano yung running time natin. And then we have 60 days for the prosecution, 60 for the defense, and then rebuttal is 15. So you have the totals on the last column, no? So the maximum, if detainee with CAM, is 175 days. That's just a little over 5 months. And then if you're detained, but there is JDR, that's 190 days, no? So divided by 30, I don't know what that is, but I think it's less than 9 months. Okay, and then for the non-detained or those at large, no, it's 195 maximum, okay? And then for the non-detained, if there's JDR, it's around 210 days, no? So then we go to judgment, okay? This is the last, sa judgment po, meron din tayong chart, and you will see that we just add the 30 days, which is the period given to you to resolve it. And at the bottom, you see it in months, no? Hindi na ako magdi-divide. So for the detained, no, hanggang judgment po, we are going to spend an average of 4.87 to 6.37 months, no, for detained accused, no? How really revolutionary, considering na yung mga BP 22 cases natin ay inaabot po minsan ng 5 years, no, or even over. And then for the non-detained, we are going to spend an average of 5.53 to 7.03 months. Ganun na po kabilis, even for those who are at large. So nakakatuwa po talaga. And then the last one is appeal, the same, no? Although of course this one will be taken under Rule 122. The same procedure, file the notice of appeal, pay the fees with the original court within 15 calendar days. And of course, the most important part, I think, is that now the decision of the RTC will be final and executory and unappealable. Yun po ang ating salient features sa summary procedure. Marami pong salamat sa inyong lahat.
Thank you very much, Justice Singh. I believe you deserve a drink after that very long presentation. Ma'am, mayroon pong tubig dyan kung gusto nyo. Kindly take your seat here, ma'am, because naghanda po ba yung first level court judges? Kasi ito na po yung quiz portion. Nag-notes po ba kayo sa mga computations? Daming math nung presentation ni Justice Singh. Inainuman ng tubig si Justice. Kasi actually, sumabog po yung chat. The judges have so many questions. But we only have a limited time. No? So we will first invite Justice Singh to entertain questions from the audience. The first part will come from our friends from the media. And the second part will be questions regarding dalawa po. May panel pala sa likod ko. Parang I stand on the shoulders of giants. Parang dapat may MCLE score tayo, no? Ang gagaling ng mga speakers natin kanina mula sa welcome remarks. Ilang units din sa MCLE. Okay, nandito na po sila. Okay ka lang dyan, Justice. Natatakpan ko kayo. So what we will do, we will start with a few questions from the media, and then we will ask questions from the judges, first level court judges that were given to us. So ngayon po, I will invite our friends from the PIO to assist in coordinating the questions from the media. Thank you.
Thank you, Attorney Elia. To start, may I call on Attorney Mike Navalio of ABS-CBN News. Go ahead, Attorney Mike.
Hi, Justice Singh. Justices, good afternoon. I'm Mike Navalio from ABS-CBN News. Thank you for the very comprehensive presentation. Bob, I noticed that you did lay down for us the number of months it might take. So for civil summary procedure cases, could be from 35 days to about 5 months. We could get a judgment. And for criminal cases, it could be anywhere from 6 to 7 months. But what's the standard now in terms of the average of cases that it takes for cases that previously were not part of this summary and small claims cases?
I can speak from the time that I was there, no, when I was an MPC judge. Summary civil, not a problem. We were able to dismiss them or to resolve them on the merits. We not longer than 8 months, no, ganyan, kasi wala ngang trial. But criminal was really the problem. So I used to have, like I mentioned, BP22 cases, which would last for like 3 years, 4 years. Meron pang dumadating ng 5 years, no? So yun talaga ang average namin noon. I don't know now because our first level court judges do not have as many cases as we had when we were there. With Justice Inting and Justice Garland, our dockets were like 5,000. Mine was 5,000 when I started. So mas madami kaming na trial noon. So less yung trial dates that we could give to criminal cases. But now I understand that they have lower dockets. So maybe it's not as bad as when we were there. But still, this is going to be really, really different. No? Kasi even if mas konti na yung cases nila, I expect na with a continuous trial, napabilis ng konti. Pero baka years pa rin yung summary civil natin.
And do you have an idea as to the cost that will be cut down because of the revised rules?
I'm sorry. Yes, the cost was discussed by Justice Garland. No? Definitely, the small claims, talagang pinakamababa yan. No? Except that we realized after the original run of small claims na marami nagbe-benefit na financial institutions. Kaya sabi namin, singilin na natin itong mga to. Kasi ang hindi dapat singilin, yung mga indigents na kaya tayo may small claims na libre para makapunta sila sa court, they can recover their little money. Pero nung nagbe-benefit na yung financial institutions, nag-impose na tayo ng filing fees, but very reasonable naman. But here, we are not changing any fees sa summary procedure. They will be the same fees that have been there for a long time under Rule 141. It's going to be the same.
Lastly, if you will permit. This is quite innovative that you now allow service through mobile phones, short messaging service, and instant messaging. Are these confined only to small claims cases? And what are the implications in terms of proving that notice has been sent? Will you now use also the rules on electronic evidence? So in short, yung scene zone po ba, can that now be used to prove that you have received notice?
Hindi ko yata alam kung ano yung scene zone. Okay. Anyway, I'll try to answer that, but I will also call on Justice Maidas after I give my answer. The short answer is yes, that applies in small claims cases only. And we deem that necessary kasi sa small claims walang abogado. So kaya yung talagang yung partido mismo, so very convenient na i-text mo sila. We don't even know kung may email sila, 'di ba? So kaya pinayagan namin yung SMS, no? And as to the proof, no? Yes, we apply our regular rules on evidence in respect to electronic evidence, no? So yon. How do you prove a text, 'di ba? So you take a picture or ano ba tawag doon? Screen photo ba 'yon? A screenshot of the message that was received or read, 'di ba? Sometimes it comes out red. Or if it's in Viber, 'di ba, you see that the double check which is colored violet. I don't know if that is it. So does that answer your question?
Yes,
I'll call
it does.
Justice Marquez also.
All right.
Sir.
Thank you, Justice Monet. Lahat yata nasagot naman ni Justice Monet Singh except yung scene zone, di ba? Kasi hindi siguro alam ni Justice Monet yung scene zone kasi bakit ba? Anyway, I think the basic policy is if it can be proven, no, that the other party has received notice, then the court will consider that as having been duly received. No? Kasi pag yung scene zone, hindi tayo sigurado kung talagang nabasa or nakita or natanggap, di ba? Kasi ano ba yung sabihin ng scene zone? You sent and then
It's marked red
NR.
or seen.
Huh?
It's marked seen or read. Can we not presume, Justice, that it's been read or received if there's an indication?
Well, it can be shown, no, that it was seen and read, then the court can consider it received. So, minsan kasi, okay, nakita natin seen or read, no? But we're not very sure who saw it or who read it. No? Maybe the owner of the phone was not handling the phone when that message was sent, no? And then the one handling the phone read it, pero hindi naman siya yung owner. So there can be an issue, no? But really what we want to do here or what we want to happen is to make things simpler, no, and easier for the parties and make the proceedings expeditious, more expeditious, no? So in these are situations that will have to be proven if it is being denied. Otherwise, if the other party will admit it, then fine, we will do that. That is why, if you notice, in small claims cases also, we are allowing other video conferencing platforms, no? Aside from our official Philippine Judiciary 365 accounts. No? So Messenger, pag pwede, pag okay doon sa lahat ng parties, okay kay judge, pwedeng Messenger, pwedeng Viber. No? So whatever is convenient and comfortable for everyone. No? Basically, we want to give the simplest platform, procedure, avenue, no, for everyone so that we can resolve these small claims cases more expeditiously.
Justice, thank you.
Salamat.
Thank you very much, Attorney Mike. Our next question will be coming from Mr. Julius Gonzalez of Radyo Pilipinas.
Good afternoon, Your Honors. I'm Julius Gonzalez from Radio Pilipinas. The question is, what is the rationale or the reason behind not allowing lawyers to appear in small claims cases?
Well, thank you. No? That rule has been there since first rule on small claims cases. And basically the reason is that we want the parties themselves to be able, no, to argue their cases, of course, with the help of the judge. You know, the judge here is actually acting like also a mediator because you're not actually enforcing all the strict requirements of rules and procedure. No? So the judge is guided by that policy, and it was said that you know, if we will allow lawyers then all these technicalities, no, will be raised, no. So to avoid all those technicalities, and so that we can just really go into the basic claim, no, we have decided, or the court has decided, you know, to prohibit lawyers from attending these proceedings, unless, of course, one of the parties concerned or involved is a lawyer.
Thanks, sir.
That's it for the questions from the media. Attorney Elia.
Thank you so much, Chair. We would like to thank the media for taking the time to join us today. We will now read questions from our executive judges who are joining us via Zoom. We have requested for their questions beforehand, some clarifications and comments on the rules. And here are some of the questions to be answered by our experts behind me. Na nagpapasahan. Under the rules on expedited procedures, are video conference hearings discretionary upon the court?
Hindi ko na po mautusan si Justice Marquez ngayon. Dati nasasabihan ko siya na ikaw na. Ngayon hindi na pwede. Opo. Yes, the resort to video conference hearings is discretionary on the court kasi that's provided for in the expedited rules, di ba? The court may on its own motion, no? Kahit walang motion yung parties, you can schedule hearings through video conferencing, no? And but that is qualified that it must be practicable, no? So dapat practical, katulad ngayon pandemic, di ba? It's very practical. And then the other one is that it must be beneficial daw to the speedy and efficient and inexpensive determination. So kung manggagaling yung isang partido nyo from a different jurisdiction, no, malayo yung panggagalingan, then definitely it will save that party cost, no, kung mag-video conference hearing na lang tayo. So yes, the answer to that is yes.
Ma'am, mukhang dialogue na lang tayong
Oo
ganyan.
nga
no?
eh.
Kasi justice na
tayo
siya.
ng boss natin.
Oo, boss natin to eh. Sir, pag mali yung sagot namin, no?
Oo nga.
At saka summary procedure daw kasi to. Ang assignment daw po niya ay small claims.
Okay, sige po.
Sige po, Justice. Okay, next question. We have 4 more questions, Justice. At alam ko, tuyo na yung lalamunan mo. Under the rules on expedited procedures, there is no extension of time to file answer. But under the 2019 amendments to the rules of civil procedure, the filing of answer may be extended for another 30 days. For 5 points, how are these provisions reconciled?
Pwede ba for 5 days of leave?
Parang bar exam
Okay.
question.
So, hindi po natin sila kailangang i-reconcile because they do not conflict with each other. Because the 2019 amendments, they govern regular cases. And we are talking about the expedited rules which govern summary procedure cases. But as Justice Garland mentioned earlier, no, dun sa applicability at saka interpretation, the special rules, special rule kasi to, you know, fundamental statutory construction, di ba? The special rule will always prevail over the general rules. So yung ating expedited rules, this is a special rule. Kaya nakalagay nga dun sa ating expedited rules, this will always prevail. If there is a provision in the 2019 amendments which applies to regular cases, which we can apply suppletorily, the condition is that it must not be inconsistent. Kasi nga, dapat ang priority is the expedited rule.
Thank you, Justice Singh. Number 3, under the rule on summary procedure, can the judge require the counsels to file preliminary conference brief within 5 days before the scheduled preliminary conference hearing instead of 3 days?
Yes, because the exact wording under Section 11 is at least 3 days. So that means that's the minimum, no? So pwede nyo abaan kung gusto nyo kasi mabasa nyo ahead of time. You can say at least 5 days or you can say even 7 days or 10 days. Nasa inyo po yun. Kasi meron naman kayong ino-observe na time frame, but the minimum is 3 days.
Thank you, Justice Singh. Question number 4. Under the rule on summary procedure, can the judge specifically require the counsels to submit a Microsoft Word format of their briefs so that a preliminary conference order may be immediately issued by the judge?
Yes, by all means, no? Yan yung nabanggit ko kanina, you can be creative, no? Kasi talagang we are left to our own devices. Paano ba tayo magko-comply dito? Marami tayong ibang kaso, marami pa tayong ibang gagawin, no? And automated hearing was a challenge. When I started that in Quezon City, ako yung unang nasalang doon and hindi ko alam kung paano ko gagawin yon during a pre-trial na doon lang sila nag-stipulate, nag-admissions, no? But you know, if you get this nga, for example, you ask for a soft copy already of their briefs, so you can do the work ahead of the preliminary conference, no? So ipasok nyo na siya lahat in the format of the preliminary conference order. And then while you're doing your preliminary conference, you're just editing it real time. Tinatanggal nyo na lang yung mga admissions na dinenay, di ba? So kino-cross out nyo na lang siya, dinidelete nyo na lang sila isa-isa. No, so by all means, do things like this. We urge you, no, be very, very creative to make your work easier. Yun ang gusto namin, na mapagaan po yung trabaho ng trial courts natin. That's why nga we have this expedited rules. Last na lang ha.
Last na, Justice. Okay, sumasabog po yung chat, but we promise to those who ask questions now, after listening to all the lectures, that we will submit your questions to the committee. Hindi ko kasi kayang sagutin. Number 5. Under the rules on expedited procedures, is the reservation of witnesses or reservation of documentary exhibits allowed before the first level courts?
Okay, so i-distinguish natin yung civil sa criminal, no? Kasi yung sa civil, very express, sinabi doon sa preliminary conference that the rule on pre-trial, Rule 18, in the 2019 amendments to the Rules on Civil Procedure are adopted. Okay, so ibig sabihin, kung ano yung Rule 18 sa ating 2019 amendments, yun daw ang papaganahin din natin sa summary civil. And that is where you find the rule on reservation. Express, no? Kasi dati practice lang natin yan eh. But in 2019 amendments, nandun na yung rule on reservation. But in summary criminal, no, walang ganon. Kasi ang nakalagay sa pre-trial, sa summary criminal, the guidelines on continuous trial, di ba, will be followed. And if you look at the guidelines on continuous trial, walang express mention of reservation, okay? But then we fall back on the applicability and interpretation, di ba, that the gaps in the expedited rules may be supplemented by the regular rules, okay, which includes the 2019 amendment. So yun po yung sagot natin doon. Pwede po yung right to reserve, no? Anyway, kasi sabi ko nga, that started as a practice. It's just that in the 2019 amendments, we deemed it wise, no, to make it already expressed para hindi ma-abuse. We made conditions for reservation of witnesses and reservation of object and other evidence, like documentary evidence.
Bigyan po natin ng masigabong palakpakan si Justice Singh at si Justice Marquez. That concludes our open forum. We wish to thank now the executive judges, thank you, Justice, and presiding judges of the first level courts for a very fruitful discussion. We know that this is just a beginning discussion. Sa PM ko po at Viber ko, hindi ko po nabubuksan. Ang dami pong questions. Sorry, but we also have to end at some point. No? Wala ring forever. To commemorate this momentous event, may we respectfully request Justice Inting, the chairperson of the Committee on the Revision of the Rules on Summary Procedure and Small Claims Cases, and PhilJA Chancellor Rosemary D. Carandang, to join us at the front to formally present for the formal presentation of the rules on expedited procedures for the first level court. As we all know, the Philippine Judicial Academy is the training school for justices, judges, court personnel, even lawyers and aspirants to judicial posts. After this formal launch, PhilJA will be conducting the trainings for the rules on expedited procedures. Justice Inting just turned over the book to Chancellor Carandang. PhilJA na daw po ang bahala sa training and sa Q&A. Pero ito na rin yung speakers, no? Sila rin. Okay. Thank you po, Justice Inting and Chancellor Carandang. We wish to express our appreciation to the Philippine Judicial Academy for their support for the publication of the rules, particularly the Research Publications and Linkages Office, and the Supreme Court Printing Services for providing the handbooks and pamphlets today. We would also like to announce, confirmed ito, no? that the soft copy of the Handbook of the Rules on Expedited Procedures for the First Level Courts is now available at the Supreme Court website. The handbook contains the text of the rules, small claims cases forms, nakita ko po may isang question about forms, and they are in English, Tagalog, Bisaya, French, comparative table of the rules, and the flowchart of the summary procedure and small claims. So paki-check nyo na lang po sa Supreme Court website, sc.judiciary.gov.ph. Mali pa, eh, no? At this point, may we call on the significant individuals who have made this event possible for a photo session. Ready na yung mga boss. We will call each group, 2 groups lang, and the succeeding group, okay? So may we request the speakers and presenters to please come over for a photo session. I will call next the members of the committee and the secretariat of the committee. So maghanda na po tayo. Siyempre po, kasama po tayo sa picture taking. So where will the photo, saan po titingin ang ating mga distinguished speakers? Okay. Please count. Thank you so much to the speakers and presenters. Please stay because we will invite now the members of the committee and the secretariat. Hindi ko na kayo tatawagin isa-isa kasi tinawag ko na kayo kanina. Please come forward for your photo session. Our staff will assist in the social distancing for this. Please. Sige kayo, hindi nyo mapopost. Before we end the ceremony, we wish to thank everybody who have made this media launch a success, starting with the various offices of the Supreme Court, Office of the Chief Justice, Office of the Associate Justices, Office of the Court Administrator, Public Information Office, the Program Management Office, the Management Information Systems Office, the Philippine Judicial Academy, and the offices that provided tremendous support to us, the Supreme Court Printing Services, the Fiscal Management and Budget Office, the Medical and Dental Services, and the Office of Administrative Services. While we are still hampered and limited by the pandemic, and the resulting health and safety protocols, the committee, under the leadership of Justice Enting, have endeavored to have this launch possible. The planning for this launch was guided by the Chief Justice through his vision as laid down in his reform agenda. Kailangan ko na ng tubig. And now may I ask everyone to please rise for the Philippine Judiciary Hymn.
Enshrined in
Maraming salamat po. Before we formally end, the members of the media are requesting for a photo session on the esteemed and Banc session hall with our esteemed members of the committee. So kung sino pa po yung nandito sa room, magpapapicture lang po and PIO will take the photo of our media, members of the media. Makakatakbo ba kayo in 5, 4, dito kayo, 3, 2,